So, welcome everybody. Welcome to the Brussels School of Governance, the University of Ghent and the University of Eastern Finland. Virtually, we are very glad to have you with us in this event. My name is Harri Kalimo. I'm a professor and co-director here at the 3E Research Center in the Brussels School of Governance and professor at the UEF in the CCEEL research group. Online with us, we have the two co-organizers of this event from Ghent University, Professor Ferdi de Ville, as well as from the 3E Center, also Simon Happersberger. We're very glad to acknowledge the support, the financial support of the Commission, the Erasmus Plus program in doing this in the form of the Equivalence Chair. So thank you for the Commission for that. Now, this event is the second in a series of events titled The Unilateralisation of EU's Trade Policies, Asserting Interests for Deserting Principles. In the introductory event we had 2 weeks ago, we were setting the scene and we identified 3 areas where the EU's trade policies are shifting in responses to a dramatic change in the environment that surrounds us. We can witness changes in the economy. There are changes and challenges in the sustainability, and same applies also for geopolitics. Today, we're focusing on the first of these 3 sub-themes, namely the markets. Earlier this week, High Representative Josep Borrell stated in a speech to EU ambassadors, and he was quoting scholar Oliver Schmidt, that the EU is decoupling the sources of its prosperity from the sources of its security. What he means by that is, as I understand it, that the EU used to trade and have security guarantees from the US. Nowadays, it has the security guarantees from the US, but is trading with China mostly. And of course, in the background, the US-China relationship has gone somewhat sour. That is putting us in a bit of a bind. And that relationships perhaps is also what is explaining partly what we're seeing in, for example, the WTO. In other words, we are facing challenges in terms of the multilateralist world that we have been used to. So how does the EU react to that situation? What can we do? The EU launched already winter 2021 a strategy on the trade front, so from the viewpoint of markets, where it is trying to engage and introduce new ways of actually leveling the playing field and making sure that even in the changing circumstances, we remain competitive and vigilant. And we have 2 legislative instruments from that strategy that have been put forth, which we are here discussing in more detail today, namely the foreign subsidies regulation. So a piece of law that is essentially trying to address third countries that are providing companies that operate their financial under help. And on the other hand, international procurement instruments, so another piece of legislation which is trying to ensure that the procurement markets in the third countries remain open for European companies as well. So, 2 very interesting legislative acts to discuss, intriguing ones, difficult ones. So to discuss them, we need, of course, the best possible experts, and we are very glad to introduce and welcome to our institute here that top-notch team. So warm welcome, first of all, to Lucian Chernat. Lucian, on the far left, is the head of the Global Regulatory Cooperation Team and International Procurement Negotiations at the European Commission, DG Trade. So great to have you, Lucian, here. Much appreciated. Next to him, Iveta Stoyanova from DG Competition. Iveta is part of the task force dealing with third country subsidies. So they're another specialist specifically on these things we are to discuss. Thirdly, in the middle, man who barely needs introductions. Not only the former foreign minister of Belgium and the president of our institute here at the Brussels School of Governance, but former commissioner for trade, and of course this discussion that we have today is something that is already have been starting at the times where Carl, you were in that role. So very interesting to hear your thoughts on this topic as well. That's the public side of things, let's say, and then looking a little bit on the private side. So on the side of the operators on these markets that we're talking about. I'm very glad to have with us Marie-Sophie Dibling. Sophie is a partner at King & Spalding law firm, and maybe relevant for the discussion to know is that Marie's clientele is mostly companies from Europe, European companies, if we simplify a little bit. And then finally, another eminent person whom all of people dealing with trade law know in Brussels, Edwin Vermoost. Edwin is a partner in the B law firm and has been representing industry in particular, mostly non-European companies in that sense. A little bit of a different perspective to Marie-Sophie's, which we think will be surely giving us interesting insights onto this discussion that we'll have here today. Now, the order of proceeding is such that we will start off, and by the way, the first part of this discussion is recorded, so for those of you online. So the first part, the discussion, will start off so that we have the two, our colleagues from the Commission introducing the legislative instruments that we are discussing in about 10 minutes each. And after that introduction, we'll then engage so that our three commentators will have a chance of 5 minutes or so initially to offer some thoughts also on these matters, and then we'll open the discussion first here for a little bit of an exchange between us, a couple of questions from me, and then of course you, the audience, will also be engaged. Simon is online and reading the Q&A there, and then we will have some questions surely from the audience as well. I think that's everything from my side. Again, great to have you, and perhaps with that, we can just simply, Lucian, get started.
Excellent, thank you. Thank you very much again for the invitation and for the occasion to present the brand new instrument called International Procurement Instrument, which was published in the official journal at the end of June, entered into force at the end of August. So we are already looking at the first ways in which this instrument can be effectively applied, as many stakeholders have illustrated with their positions over the long history of this file. Many of you maybe remember that this file was launched by the Commission in 2012, I think. So the IPI is now a newborn, but it's almost a teenager, right? So it's been there for almost a decade. It's one of the longest debated legislative proposals. It was almost, yes, I think there was a period where we had to put the instrument on intensive care and maybe some deep soul searching before we managed to convince everyone who had to convince, including some member states, some business stakeholders, some parts of our policy-making process, that it has value. And I think it has more value today than what was originally presented, for a few reasons that I'll try to explain. First, although the IPI is presented, and I think there is maybe some good reason for it to be conceived and presented as part of a full package of instruments that one could call unilateral actions. In fact, the International Procurement Instrument, I think, has some specificities which will not qualify it entirely as a unilateral instrument. In fact, if you look at the the overarching objective, the underlying logic of the instrument is to promote openness, is to ensure that we guarantee level playing field and reciprocal access to public procurement markets around the world. So for that to prevail, one would need a partner, a willing partner. In IPI, to call it a success, at least from Digitrade's perspective, IPI will succeed when it takes two to tango. We will need to have a positive engagement in the consultation phase, which is envisaged in the instrument, for us to try to obtain satisfactory measures that will allow European companies to bid on a level playing field with domestic companies in that country where concerns are raised. So, I mean, from that point of view, it's not really a unilateral instrument. It becomes, if you want, a unilateral instrument the moment we fail in our consultation process with third countries, the moment we obtain no satisfaction in terms of measures that will redress the initial barriers that have been identified, in which case the IPI stipulates that the Commission may introduce IPI measures, which are restrictive measures, of course, that have to be agreed in Council with the Member States. And once that agreement is reached, then we would unfortunately then be in a position to restrict access to operators from those third countries to the European market in a proportional manner. So the proportionality principle is clearly introduced in the instrument. So I've already tried to illustrate some of the steps and the underlying logic, but I think also very important and that to back up my statement that IPI is more important than ever. If we look at the current geopolitical context, the recent very prominent measures that some important trading partners have put in place, you can easily detect a much more negative business environment when it comes to public procurement, international public procurement worldwide. Simon Evanet and his team at Global Trade Alert, they systematically collect information on public procurement barriers among many other kinds of barriers. And by their count, I think we could easily spot nowadays over 500 individual procurement barriers worldwide. So the scope of IPI is defined by the barriers that our companies will complain about. Let's not forget that IPI has two ways of being triggered. One is based on complaints from business associations or companies who would have to substantiate their complaint. Of course, there are clear elements of that, or through an ex officio case where the European Commission will initiate an investigation whenever we have good grounds to do so. So that allows us to calibrate our future interventions on areas where we know that we have had significant barriers in the past, where the level of discrimination has increased recently, where the economic losses, not just for Europe, but also for those countries who probably just say no to the good cost-benefit ratio for some important project that they pursue with public spending. So we need to be mindful of the economic stakes involved. But I would also say, at least from my personal viewpoint, that IPI is also a diplomatic tool. It requires, as I said, a cooperation with a third country. So you need to if you want to preserve a level playing field and to in fact increase market access, you need to use the instrument wisely, especially whenever you think that there are elements which will allow you to increase leverage on the European side in various diplomatic discussions, trade discussions with partners. Now we have an additional tool that will hopefully give us leverage to push the end result towards a more trade creating outcome. So I will stop here. I hope I gave you a gist of how it was conceived, how we hope it will be used, and also we will see exactly where we start. For the time being, I think both the European industries and the Commission, it's still early days. We have not yet made any concrete initial plans for an immediate action, but the instrument is there whenever it will be necessary. We're ready to use it.
Fantastic. Thanks so much, Lucien. Very clear and concise. We'll come back to various points you raised in a moment, I'm sure. So, Iveta, thank you.
Thank you. So I did note of what Lucien has said, and if I can summarize perhaps the similarity between the two instruments, that would be the intention to guarantee or at least take care of the level playing field within the EU. But while the IPI can be seen more as an outward-looking instrument, the FSR as such is more concerned with what is happening within the internal market. In essence, the FSR is considered to be a mirror image to the extent possible and to the extent appropriate to the state aid control, but in terms of what is granted by third country governments. Of course, there are certain very important differences, like for example, in those who know state aid, they know that state aid is in principle prohibited, whereas the foreign subsidies are in principle allowed as long as they don't distort the internal market. And then the second major difference is, again, I want to underline this point, is related to the distortion. We, as the enforcer of those rules, we would want to make sure that we pay a lot more attention on the presence of distortion when we assess potential foreign subsidies for a distortive effect on the market. And what I think it's important is to mention the guiding principles that we took into account when we were designing and also negotiating with our partners from the Council and Parliament regulation, and that is we don't want to close the internal market to foreign subsidies. That is not the idea, or the investment in general. The idea is just to tackle the most distortive ones, the ones that would reduce the competitiveness on the internal market. So for that purpose, we have taken use of different mechanisms like high thresholds for notifications for the two tools that rely on ex-ante notifications. And also one of the other points that we were very fervent about was the fact that we wanted to minimize to the extent possible the administrative burden for companies that would be subject to the also, when designing the rules, we tried to pay as much attention and as much importance to compatibility with our international obligations in the area of trade and with the WTO obligations. Also, when you read the text of the regulation, you will see that the principle of neutrality is enshrined very, very much into the text. And also, we have tried to not create conflicts with other instruments that are already available and that might tackle some of the problems that could be also tackled with the FSR. So, for example, the carve out for anti-subsidy and countervailing measures that is present in the regulation. It's also very important. This is very shortly with regards to how we see the purpose of the instrument on the market. I think another thing that is important to say is that we are lagging a little bit behind our colleagues from DG Trade. So far, the text has been agreed at political level at the end of June this year. We expect that by the end of the year it will be officially adopted. And then in terms of next steps, this would mean that it will start to apply by mid next year, with the notification obligation kicking in 3 months after that, so by October 2023. Interestingly, I think also for the audience would be to say that most of the stakeholders are very involved in the process, but not in a negative way. To the contrary, we have had many meetings with companies that might be subject to the notification requirements and who are willing to know more on how we will apply the regulation, and also preparing to start submitting notifications from this point.
Okay, I think we thanks. You may continue. Just maybe that for the audience, for the micro project.
The only thing that I wanted to finally say is that for this purpose, we are preparing an implementing regulation that would also be published for public consultation by the end of this year. Okay.
Thank you very much, Iveta. That's concise, and maybe some aspects can be even developed further as we discuss. Carl, let's move to some of the comments. I said you go back all the way to the times that Lucia referred to, so perhaps some anecdotes from that and reflections on where we are today.
Well, Harry, you said that this is part of the unilateralization package. I don't know, because we have TDI for goods for decades, and it has never been looked upon as a unilateralization tool, although it also applied to countries we have, for example, a free trade agreement with. So it's not about unilateralization, it's about how can you protect your interests in a way that is compatible with the WTO, that creates a level playing field, and where all countries are just on the same lines of thinking, whether they are friendly or not, whether they are FTA countries or not. So what I would expect, and that's my point, is that we should do the same with services, but I come back to that in a minute. With respect to IPI, I'm the original author of IPI in 2012, together with Michel Barnier. And I think 10 years ago it made sense. Now it doesn't make sense anymore. So there I have really completely different opinion, because you are not going to convince the Chinese of anything. And you have to be very careful that you don't make a concession on paper, that for them it stays on paper and that you will do it in practice. I think that China over the last 10 years has dramatically changed, has become much more self-confident, and in fact are not at all open to that kind of negotiations anymore. Where they open their markets and they think it suits them well. And some markets they will do because it suits them well. But all the others are simply closed. I mean, and the idea that you could force them to be more open, I don't think so. Now you could say it's not only on China, it's also on other countries that it will be focused. Yes, maybe. I mean, maybe that's then the second tier reasoning, that, for example, it could also work with India. I think with India, you would rather try to have a trade agreement, and it seems that they are now nearing that phase. Whether it will realize that still something else, and because we have also been in the last 100 meters, and then we were stuck by the cutoff price for whiskey. So, and since then we got Modi, who is certainly got a free market here. It's not with the opposite. So I don't think that you can create openness with the IPI. I think the momentum should have been used immediately after 2012. Then the Commission went down with the ambition. They had in fact to come back to the original version, more or less, but 10 years late, and I would say even too late. But let me concentrate on FSR. You know, I've been doing the TDI for 5 years now. The start, I mean, I followed this very closely. And there are a number of lessons out of this. First of all, although you could approach a lot of those cases through the lens of subsidies, we all did it through the lens moving away from subsidies and taking the other line, because we realized that subsidies are very difficult to not only to find them and then also prove the link, you know, and it's quite different with dumping, because there you look at what the situation is and on the basis of that you work, and it has even produced a staff working document after the, let's say, the Chinese would try to become a market economy. So most of the cases, 85 to 90% on the basis of dumping, and in almost all these cases, of course, there are subsidies that are involved, but you take it the other angle because it's much easier to prove. And it will also prove very difficult in this new instance. Secondly, it's not giving any leverage to the companies, to the industrial sectors. What is said is that we will carefully look at it. That's dangerous, and when you're right, we are going to carefully look at it. Because this instrument is completely in the hands of the European Commission. You cannot force them in any way at all. It's really up to their discretion. Then you come very close to what an ex officio is. Now, when you look at the ex officio procedures, they are extremely limited, certainly in trades, and even if it is a comp instrument, it's about trades, and intimately linked to trade as a whole, because most trade is a mixture of goods and services. So then you have a second problem, that you have no leverage to the companies, and that's why TDI works, because when you have a representative sample of a sector that introduces a complaint, the Commission has the obligation to launch an investigation. That's completely missing here. I think that's a major fault. Thirdly, you mentioned it, by the way, the thresholds. Thresholds are very high. Because what you do, and that's understandable, you look at the global competition on the internal market. Now, the problem for an individual company is that it ends up in a completely impossible situation as a result of subsidies and dumping and you name it, and they have no way to react. You only look at what's happening globally on this internal market. The thresholds are also very high. It's 250 now, isn't it? For public procurement, which is a lot now. I mean, for certain sectors, you never get there. Now you can say, okay, even if it's less, you can still do it ex officio. I would like to see the ex officio procedures in DG competition. I mean, you are astoundingly against the lowering of the threshold, because you say then we need much more personnel, which is true, by the way. And you cannot get it or even go down with the personnel. So I think it's really not the way you should approach it. There's also no possibility to do it outside the framework of public procurement. TDI can also work outside the framework of public procurement, which is very important, because quite a lot of public procurement that in fact is presented through the lens of private business. And if you look more clearly, it's not private, it's at least. In any case, it's mixity. And maybe a last remark on the threshold for takeovers, 500 million. That's low, by the way. If you compare that to public procurement, 250, the 500 is very low for a takeover, because a takeover of 500 million is normally not, let's say, disturbing the internal market as such. And by the way, I have a little bit of experience also after my life as a commissioner in mergers and takeovers and so on. There's only one price for a company, that's the price somebody is ready to pay, you know? And that in most of the cases has not that much to see with subsidies, but whether you are eager to have it, whether you think that it can be, it's important for you for strategic reasons, either to grow or to make that the others do not grow. But I mean, this is something quite different, and it doesn't have to see with subsidies, if you ask me. Of course, there can be subsidies involved, but that the subsidy is the reason that the Chinese would pay more. By the way, it would not be the reason. The reason they would pay more is, for example, that they need it for strategic reasons. Huh? You know what the beginning of this whole discussion has been? This company in Germany, what is help me, the high-tech company that the Chinese acquired. And that was, in fact, the beginning of the whole discussion on this, which was not a very big company, but it was very. Yeah. So Kuka, that's it. Not Kaku, but Kuka, that's it. That was the whole discussion where Germany became in favor of such a kind of approach. Last remark. We should be very careful on subsidies. because recently in the European Union, we are subsidizing as hell. That's the fact of life. And since COVID, that's what we like the most, we subsidize. And without a lot of control. So be very, very careful on this, because you should know, even without lawyers, that the Chinese know very well what is happening in the European Union. Sometimes they even know it better than we do. Be very, very careful, because we are subsidizing like hell. So I think this is not the right approach. What we should have done, for whatever reason they don't want to do it, we should have framed the TDI for services. That's what we should have done. The more so that almost all products, product is something that you can put on the market. It's a mixture of services and goods. And you have now two different procedures. So when will they come together? So it's a mistake. It's a clear mistake, but okay. Of course, defense law officially also it's a mistake. It will not solve anything.
Thank you on these notes. Lots of things to think about, also for understand. But let's move next to Maria-Sophia. A few thoughts from your side.
Excuse me. Just 1 minute. Like some people in the audience have a bit of difficulties to understand you. So I would ask the next speakers if you please could speak up a bit louder. Thank you very much.
Just going to say that indeed. Go ahead, Maria-Sophia.
Thanks very much, Harry. And not really easy to talk after Mr. Ghent, but I will try. I will do my best. I would like to make a few general comments and then briefly discuss the two instruments with a particular focus on the IPI. Few general comments first, focusing on the context in which those instruments are being developed. First important point for me is that the WTO rules have not been updated for the past 20 years. And so for me, we are dealing with old international rules to address new trade challenges. Second important point for me is that the EU is not a country. It is an international agreement between 27 nation states. And so multilateralism is in the DNA of the European Union. And you cannot go against multilateralism, because if you would do so, you would put into question the very existence of the European Union. And this is important because this has a big impact on the way we do things in Europe. We have processes that are much longer, and we have mechanisms that are much complex. So not always easy to navigate when you are a European industry that are willing to use all these types of instruments. And in this context, the Commission has been developing new instruments because there are gaps, and because the gaps cannot be solved at the international level because the negotiations are not progressing. And those new instruments, they do not conflict with the existing international agreements, but rather I believe that they complement them to fill the gap. So with these general comments, I would like to move to the two instruments now and to say a few words about the IPI. And that is funny because I wish to start by saying that 13 years ago when I started my practice as a trade lawyer, and we went to the Commission talking about reciprocity and this nice idea of reciprocity, the Commission services were not really responding to that point. And I'm really happy to see that, things have evolved positively, and that for me, we are going into the right direction. Of course, I also agree that the IPI arrived late, but at least it is there now, and I'm also very happy for that. It is an ambitious instrument. The EU is a big market, and we have a lot to sell to our competitors if trade is fair. I mean, if it goes both ways. So, as you said, I think it is an instrument that would provide a leverage to open new markets for EU industries. And I think that is for me the interesting point here is that it is an instrument that should level the playing field on export markets. And that is interesting. It is also very ambitious for me because it is a well-done instrument. It has good realistic deadlines. It has good circumvention practices. It has also rules to ensure consistency with the successful bidders, and it has also exception and exemption, but that are quite moderate. I understand it would not apply when there is an international agreement in force. So, for example, the WTO government procurement agreement, and I see it a bit of an issue here because the GPA is less ambitious than the IPI. And because the GPA would require the WTO panel to get remedies, and I don't think it's a solution for European industries. So I am in the view that the IPI could perhaps better protect the European industry than the GPA. For me, the big challenge on the IPI instrument will be really the implementation, courage of the Commission to implement it correctly, not only a political tool, but really a weapon. It will also, for me, be a big challenge for companies also to use it and not be afraid about retaliation. That is a big issue for me, but I believe that the instrument is sufficiently flexible to find solution on any risk of retaliation. I also believe that maybe there could be a consistency between the coercion, a draft regulation at some point. And that's all on the IPI. I want to turn to the foreign subsidy regulation, and I think you are going to discuss that, but I just want to say a few words on the industry aspect. I think this instrument is really capital for the European industries, but it has to be ambitious. It has to be ambitious. This is very important. And for us, the issue remains on Article 40.7 and the articulation, as you explained, with the Article 32.1 of the WTO SCM agreement, because then I understand that if the SCM agreement applies, then the foreign subsidy regulation would not apply. And this could be a big issue for European companies. And I want to provide, or at least try to provide, two examples for which I think there would be a need for clarification. The first one is the issue of the shipbuilding industry. So there is something for the time being in the regulation, in the draft regulation on Article 40.4, which address the issue of the shipbuilding industry, because the shipbuilding industry cannot use the TDI rules. It just does not fit with their specificities of the sector. And I understand that the draft FSR would apply until the TDI regulation on shipbuilding becomes applicable, if one day it becomes applicable. And I don't see the articulation. I'm still struggling with the articulation between Article 40.4 and then Article 40.7. That's the first point. And the second point I want to make, and maybe it's a bit technical, so I can rephrase at some point if you want. It relates to the export taxes. So some countries apply the export taxes, export restraints, to prevent a new company to get access to competitive raw materials. The Commission has already said that it is a subsidy under the TDI instrument, so that's a very good thing. We still have the court on that, but the Commission has recognized this is a subsidy because it provides a benefit to the competitor, to the producer in that country concerned, because they get access to cheap raw materials. So now let's assume that you have a situation where you have an EU vertically integrated producer that has to purchase the raw materials, paying for the export tax, transform the product and make a final product. And then you have a competitor located in a country which applies an export tax that can get access to cheap raw materials, transform an intermediate product, and then has a subsidiary in the EU that makes the final product. You have an issue of level playing field here in the internal market. My question is, would the FSR be relevant and applicable for that kind of issue? I just want to highlight that there are still gaps, and I just hope that, you know, all the instruments that we are producing would, ensure that we can fill the gap at some point. I will stop here. Thank you very much.
Thanks, Rosemary. So, thank you very much. I think the general question in this series of seminars is whether the EU trade policy is moving in a unilateral direction. I think that is clear. That is clearly the case. It is becoming more unilateral. Of course, I agree with Mr. De Hug that TDI in a way are unilateral, but these are unilateral instruments clearly envisaged by the WTO. And here, in some ways, we go beyond that, I think, because it's not so clear whether these new instruments are WTO compatible. But on the other hand, times are changing. So I think it is not debatable that we are moving in the unilateral direction, but that in itself, I think, is not necessarily wrong, as long as it's done in a WTO compatible manner. Because times have changed and countries in general are moving in a unilateral direction. The United States very clearly, China maybe, as you mentioned, other countries. So whether or not we're moving in a unilateral direction as EU trade policy, I think is in a way beyond the point. It's a station that has passed. But it seems to me that these instruments should be assessed rather from a different perspective or perspectives. Namely, are they good policy? Number one. Number two, are they good laws, the way they have been drafted? And number three, are they good in terms of their timing? And in those three, from these three perspectives, I reach different conclusions with respect to the IPI on the one hand, and the foreign subsidies regulation on the other hand. I think the IPI is good policy. It makes sense. You exclude in principle sectors or countries with which are members of the GPA, or with which the EU has concluded FTAs with the government procurement chapter. So you target the countries that do not give you similar concessions that you basically give to those countries because you have an open market, relatively speaking. So it's good policy. In terms of the law, I think it depends on the application. If it is very aggressive, and one issue obviously is in the area of the remedies, potentially the remedies can go very far. You can exclude a country from the EU government procurement market. So that's an extreme remedy. I doubt that you would go that far, and I think some of the other commentators have expressed the same thought. But so whether it's good law, in my view, depends on the application. In terms of the timing, I think, in my view, it's better late than never. It should have been done some time ago, as Mr. Ludwig rightly said, but better late than never. Then, on the other hand, the foreign subsidies regulation, my conclusions are completely opposite. I think it is bad policy. I'll come back to that. It's bad policy. In terms of the law, I think, again, it depends on the application, but I think it will be applied very aggressively because it is clearly patterned after the subsidy practice, the CVD practice of the EU. And the CVD practice of the EU in recent years, and I differ in that respect from you, Ms. Muir, has been very aggressive. I'll come back to that in a bit. In terms of timing, I think the timing is horrible, and in that respect, I completely agree with you, because as you rightly said, the EU is subsidizing in an extreme manner at the moment, and I have just two examples from this week, actually, or from the past 10 days. And one is a decision of the Commission to allow a grant of 300 million to ST Microelectronics to set up a silicon carbide wafer plant in Sicily. The total investment is 730 million of the company. So that's a subsidy, it's a grant, it's a subsidy of 40%, not taking into account the time value of money. You certainly know the time value of money as an economist. You get it up front, it's worth much more than the bare amount of the subsidy. A second example, Slovakia was recently granted permission to give 1.1 billion to decarbonize its industry, the industry that is falling under the EU emissions trading scheme. So both of these are clearly specific subsidies, and they are, I don't know the impact of the Slovak subsidy, but 1.1 billion is huge, and Slovakia is not a big country. So I would expect that that's a huge subsidy too. So why did I say that the timing is poor? Because it comes at a time, like Mr. Dirk also said, that the EU is extremely heavily subsidizing its own subsidies in a specific manner. Am I talking too loud?
No, no, no. I'm just trying to follow up because we have the online audience as well. So just making sure that we. Okay. I'll follow.
He wants to disturb you.
No, he doesn't like what I'm saying.
No, the guy.
He doesn't like what I'm saying.
It's intentional.
Yes.
Yeah. At least you didn't blow your nose. So I agree with Marie-Sophie. Before that, I would focus more on the foreign subsidies regulation, and I will do that. Because as you can, I think as you can understand from what I've said until now, that's where my heart lies, so to speak. And my first point is that I think a kind of a fatal, not necessarily a fatal flaw, but a flaw is that it is a mixture of concepts from the SCM agreement and the state aid law of the EU. It's neither one nor the other, it's a combination. And the definition of subsidization, I think, clearly comes from the SCM agreement. On the other hand, the notion of distortion of competition comes from the state aid practice of the EU. So that makes it more difficult, I think, to defend it internationally. My second point is that, and here I disagree with Mr. De Geer, subsidization findings, in my view, are almost a foregone conclusion, especially when they are granted by third countries that, in the eyes of the EU, do not have a market economy. And the CVD practice of the EU, each case against, for example, China, most of the cases in recent years have been against China, the EU has found substantial, very substantial subsidies, I would say 10 to 20%, very often, because of the methodology that is used to find subsidies in the case of China. So subsidization findings are very easy. And related to that, there is kind of a circular logic between findings of subsidization and competition distortion, because once you find certain subsidies, automatically they are very likely to distort competition. For example, subsidies to aiding enterprises, unlimited tax debt guarantees, or export credits that are not in line with OECD agreement on export credits. These are subsidies that are supposed to be almost automatically lead to a finding of distortion of competition. So it's circular logic, right? One automatically or almost automatically leads to the other. The notification requirements, I think, are low for government, for mergers and acquisitions, like you also said. They are high for government procurement, but of course the subsidy for government procurement is very low, 4 million. Right? 4 million is enough to find on government procurement. If I'm wrong, if that, feel free to correct me. A fourth point is that it also covers EU multinational corporations that benefit from foreign subsidies. But of course, it does not cover the subsidies that the EU companies get from the EU or from EU member states. So there's a clear discrimination there in my view. Now you might say, well, those are covered by the state aid rules, but as we have just discussed, state aid rules are full of exceptions. Exceptions and exemptions. And that in fact is my next point. There are many exemptions and exceptions in the state aid regime, but you don't have those under the SCM agreement. You know, the SCM agreement, the subsidy, if it is specific, there's some other conditions, but then it is countervailable. And because you have taken the subsidization definition from the SCM agreement, you can act against those subsidies. Of course, it depends, as I said at the beginning, how you will apply the law. That is clear. You have the balancing test, and perhaps you might say, if, for example, China gives subsidies to deal with the environment, those would come in under the balancing test, so we don't take them into account. But that's not clear, of course, at the moment. My last point, I think I'll keep it at that, and that's maybe more a question. In the context of the SCM, of the countervailing duty practice, the EU has this concept of fungibility of money, which means that if you get a subsidy, it does not really matter necessarily for what purpose it is used or for which product it is used, because money is fungible. And so suppose, for example, I think this is the standard case on the issue, you have a countervailing duty case on steel wire. The company gets subsidies for fishing nets, for making fishing nets. The EU will say, or the EU said in that case, the practice is not consistent. Money is fungible, so it doesn't matter that the subsidy was not given to the product that we are investigating. It is given to the company, and the company can use that money also to benefit its steel wire production. The practice of the EU on that point is not consistent, but it has been applied in that manner. So perhaps that would be, but maybe it is premature to come up with these kind of questions, but it would be interesting to see how this will be applied in the context of the FSR.
Well, that's a very long list of things already listed, so thanks very much for these insights. Very intriguing points by our commentators. I'm wondering, I have a couple of questions, of course, you're lined up, quite a few of them, but perhaps maybe first, if there's anything immediate that Yvette was saying, want to comment on, there were some of the points raised, anything that you would specifically like to address already directly, or?
On subsidies, because I say it's easy to discern certain subsidies. For example, export subsidies and that kind of things.
I think, Carlo, we need to speak up a little bit for the microphone.
There is a microphone.
It's on.
It's over there.
So it depends which kinds of subsidies you're talking about. For example, export credits at a very low price, that's easy to demonstrate. But general subsidies to a company, as it happens in a number of countries, that make it possible to act differently on the markets. But then trying to prove the link with the specific issue you are addressing, that's much more difficult. And that's what you will be confronted with. That's how in practice it works. And you are in fact losing a tool by limiting it to subsidies and not having also the other approach of dumping. That's my point.